Welcome to the Deal Making with Laura DiFrancesco podcast. I'm Laura DiFrancesco, your host. We're talking all about mergers and acquisitions, buying and selling small businesses, as well as corporate law. We are taking our experience closing over $10 billion of transactions since founding Dean Street Law 5 years ago, and my experience being an M&A and corporate attorney for over a decade and making it accessible to you as an entrepreneur. I hope that this helps you in navigating the complex world of mergers and acquisitions. And also, we're always happy to be a resource for you here at Dean Street Law. You can always apply to work with us through our complimentary consultations linked in our show notes. And a huge shout out and thank you to everyone who's subscribed and left us a 5-star review. If you haven't yet, be sure to subscribe and also leave us a 5-star review. It's one of the best ways to support us as a small business. And also be sure to share with your friends and colleagues on social media, through text, email, or however is easiest. It means the world to us that you're supporting our content and helps us make more to support you in your journey. Welcome back to another episode of Deal Making with Laura DiFrancesco. I'm your host, Laura DiFrancesco, founder of Dean Street Law. To date, we've closed over $10 billion of transactions and specialize in lower middle market mergers and acquisition. Today's conversation is all about membership interest purchases. A lot of folks get confused, especially if they're new to mergers and acquisitions, by calling a purchase of the equity interests of a business a stock purchase, regardless of whether the entity being purchased is actually a corporation or an LLC. So in every single state, they have different laws regarding how an entity may be structured and what the particular nomenclature is for that specific type of entity. So a corporation has stock, and sometimes the legal term for that is shares. State by state, it differs. So whenever we are working on a transaction, we're always going to the laws with respect to that state and seeing, is a corporation, is the defined term for the ownership interests in that corporation shares or stock? And so when you hear a stock purchase, you're purchasing the equity interest, the ownership interests in that corporation. But it could also need to be a share purchase depending on the state that it's in and the laws surrounding it. And then when you have an LLC, it's actually called either a membership interest purchase or a limited liability company interest purchase. So a lot of folks, if you are green and new to mergers and acquisitions, may not know, but there is actually many different types of quote unquote stock purchases, which I would consider more of an equity purchase or an ownership purchase. And while most people call it a stock purchase just for ease of not having to say stock or limited liability partnership interest or limited liability company interest or membership interest purchase, yes, stock is the nomenclature. Most of the time, it's not actually factually correct based on the circumstances, especially because many small businesses are limited liability companies. So with that said, let's talk about the specifics around a membership interest purchase, limited liability company interest purchase, essentially the process through which you would be purchasing the ownership interests in a limited liability company and how that will differ state by state based on those specific laws with respect to that type of company in that state. Now, one of the things that people also don't realize is that in a stock purchase, you still have to look at the laws of the state, especially because in different types of legal organizations, there are different defaults, rules, regulations, things that have to be complied with. And actually, corporations have the most legal regulations that have to be complied with. That's why it's one of the more complex types of legal entities that has the most rules of operating the business, has the most administrative requirements, having to have a board of directors, shareholders that elect the board of directors, officers elected by the directors. So it has a lot of processes involved in it. And what you may not know is limited liability companies are actually more of entities of contract. And so there are default rules for sure, but there's actually more across the board that limited liability companies can do to customize the terms of their ownership, voting, control, distributions than a corporation. And for that reason, approaching the sale of the ownership interests can be very different, because while a corporation has a more standardized set, albeit considerably more heavily regulated set of rules that must be complied with to transfer the business, the limited liability companies can actually have considerably more and different and novel, distinct rules that must be complied with. So you both have to, in all situations, comply with the law in which the state is organized to transfer the ownership interests, but you also have to comply with the organizational documents of the business as well. For a corporation, that's going to be your bylaws, shareholders agreement, etc. And for your limited liability company, depending on the state and what it's called, it may be a limited liability company agreement, operating agreement, or similar type of contract between the owners of the business. So your organizational documents are all key to approving the transfer of that ownership interest in the business. And actually, there's a lot to it. So there's a lot of different characteristics that will be covered within these organizational documents, especially with limited liability company. So you have economic versus management rights. Economic rights are going to be your distribution rights and your ability to make capital contributions, get them repaid, and then also make distributions and make ownership draws from the business. Then, in addition, you have management rights, which are the rights to manage the business on a day-to-day basis and make certain key decisions on behalf of the business. And that limited liability company could be managed by a manager, a board, a member, a group of members, a group of managers and or officers. So with limited liability companies, there's so much more flexibility. And so if you're not knowledgeable and you don't have the right legal counsel to help you through the process, it can actually be more challenging to transfer the ownership interests in a limited liability company than it can be to transfer them in a corporation, because it can be so nuanced in the organizational documents. You have to make sure that you're doing everything in accordance with those. And so you have to make sure when you're transferring the business that you're also considering removing all of the management folks that are a part of the seller group and actually electing or appointing, whatever the processes may be, in the old documents, or if you're going to have new documents, in those new documents. So whenever we're going through the process, we always like to tell people that you're going to have 10, 15, sometimes 20 transaction documents. And if you're doing a stock purchase or a membership interest purchase, that is going to include resignations from anybody holding management positions that you don't want continuing post-closing, and appointments. And those appointments may be needing to be consents or actions of the board or actions of the members in limited liability companies. And all of that has to be in compliance with both the outgoing governance documents and the incoming governance documents. So I know that people sometimes think that they can DIY it, but I can assure you that there is so much nuance to all of these things that it's not recommended at all. And it is really important to have a great legal counsel on your side to assist you with this entire process. At Dean Street Law, we do this regularly for our clients, and of course, happy to talk with you about your transaction and support you through that as well. When it comes to navigating corporate law, entrepreneurship, and managing small businesses, experience matters. Dean Street Law is a boutique corporate firm specializing in mergers and acquisitions, and additional focus in real estate, commercial transactions, finance, and corporate governance. With over $10 billion in deals closed, Dean Street Law has extensive experience representing hundreds of clients in thousands of transactions, from small businesses to Fortune 500 companies. Whether you need startup guidance or advice on closing multi-million or multi-billion-dollar deals, we're your trusted partner every step of the way. Visit deanstreetlaw.com in the show notes to schedule a complimentary consultation. In addition, you're going to have to talk about and go through with your accountants the capital accounts and the current state financially of the business. And then there's also voting rights, which are different than your economic rights and your management rights. So your management is from a day-to-day point of view, being able to take certain action on behalf of the company, but voting rights are going to be substantial changes in the business, things that might require a supermajority vote or a unanimous vote. Most of the time, if you're talking about a sale of the business, it is going to require some sort of unanimous or supermajority vote. So we want to make sure that everything that we need to do to make this transfer valid, legally binding, is all going to be completed as part of our transaction process. And then in addition, like I said, there's so much more that you can do with limited liability companies than what you can do with corporations. So there may be different ownership structures that are more unique with the limited liability company. It could be a single member limited liability company, or you could have different classes of interest, different profit or loss allocations with those economic rights. There may be different processes for establishing what those distributions are, what those profit allocations are. And then also the tax component. Does that mirror the profit and loss and distribution economic rights, or are there different tax burdens based on whether a certain different type of class membership interest or otherwise it is? So all of those are considerations. And then as we're talking about how to complete the transaction in compliance with the outgoing and incoming governance documents, you have to consider transfer rights and what are the transfer restrictions on those transfer rights. And so not only who needs to approve it, what processes do we need to go through, but then in addition to that, sometimes there's also transfer restrictions. In a corporation, this might be a shareholders' rights agreement or something like that, but in an LLC, this is typically in your operating agreement or limited liability company agreement. This can include right of first refusal, where someone has the right to match an offer that a third party makes. So if you're a buyer coming in, someone might have the right to match that. Tag along rights, where a majority interest is ready to sell, and then the minority interest has the right to tag along and be bought out at that same price. Or drag along rights, where the majority interest is interested in selling and they have the right to force the sale of the minority interests. And there's so many different components to transfer restrictions. So you have to make sure that your attorney is looking over that in due diligence. One of the recent due diligence processes that we just went through, we found the shareholders agreement, reviewed it, and said that they needed to dissolve this shareholders agreement prior to closing. So that was something, and this was super simple. It was just between two people. So really there was no reason for it to be as complex as it needed to be, but they're thinking ahead in case the business grew considerably more. And then there's a lot of governance provisions that are going to be in your outgoing and incoming governance documents. So as I mentioned, you almost always want to amend and restate the governance documents if you're transferring ownership. Now, sometimes they're good enough that they don't need to be touched, but most of the time they will need to be addressed in some way because you don't know what type of governance documents they have in place, and you have to make sure that it's cohesive with what you want the governance structure to be, whether you have a hold co or whether you have a complex structure or you want it to be simple so you don't have to have annual meetings when they're not necessary. So your governance provisions that are going to be key in both your outgoing and your incoming governance documents are manager consents requirements, their decision-making thresholds, what require member approval rights, and what are protected decisions. These are things that we have great conversations with founders about, and making sure that everybody understands what day-to-day management decisions may be made without member approval, what requires member approval, and whether those conversations about whether that existing governance structure should be restructured, and then what minority protections. These are just a few of the conversations that we have. We have a 13-page questionnaire that we go through when we're forming businesses, so that just LLCs, for instance, when we're forming LLCs, to make sure that you're considering tax, governance, management, voting, economic rights, all of the things. It's so important to make sure that you have all of these things that you're considering as you go through this process. Unlock the power of in-house legal expertise at a fraction of the cost with Legal Foundations. Gain immediate access to a comprehensive legal crash course for business, a rich library of on-demand video legal support, and the opportunity to apply for group consulting with Laura DiFrancesco as your legal mentor. Whether you're starting up or scaling your business, Legal Foundations has everything you need instantly available. Join now and position your business for success. Visit lauradifrancesco.co/the-shop for more information. As I mentioned, this is a big focus in due diligence. You have to make sure you find these things. As I've said so many times before, due diligence doesn't kill deals. It does show you what needs to be addressed to be able to legally effectuate the deal and to address things that may come up that need to be addressed ultimately. And so we're going to be looking at the historical distributions, capital call history, what would reveal poor management, have there been past disputes, and then also compliance assessments with respect to making sure their filings are good, they're in good standing, that they have tax compliance and a tax clearance certificate, and then what regulatory requirements need to be complied with to move forward. All of these are going to influence your purchase agreement, your approval mechanisms, the representation of who's signing what documents, as well as what representations and warranties are included within those, and if there's any economic impacts to any of this due diligence as well. There's also that post-closing integration that I mentioned. We have to make sure everything is addressed pre-closing, that we have our resignations ready to be effective as of closing, that we have our approvals and appointments to be effective as of closing, that we have our amended and restated documents ready for closing. And then if there's anything else that needs to be handled post-closing, whether it be communications or managing transitions of management, integration steps, and if there's existing members or owners that are going to continue on, how do you preserve those relationships and make them great working relationships? Of course, tax is one of those considerations as well. There's a host of things to consider when thinking of tax implications of any transaction, and especially a limited liability company, whether it's an S corporation, how it may be owned, or if it's not an S corporation, how is it structured? Is it pass through? And so considering all of that together with your accountant, those are all things that we focus on in the due diligence to make sure that everything is structured throughout the transaction in a way that will enable it to successfully come to closing and protect you well post-closing as you need to. This will generally also impact your funding or be impacted by your funding, who may own the business, and what the membership restrictions are going to be. If you have an SBA loan and there's a certain amount of percentage ownership, such as 20%, they will have to sign a personal guarantee as well. So there's a lot of different considerations, as you can see in this process, but it's something that we're well versed in and that we work with our clients through in a great manner, from putting together a letter of intent. We always like to request the ownership information prior to submitting a letter of intent so that we know what it should include, and we include a representation and warranty of who the owners are and have each of the owners sign the letter of intent. And then we work that way through due diligence, through the transaction documents, approving the process, taking care of all of the different restrictions on transfer otherwise that may occur and need to be addressed throughout the pre-closing documentation, closing, and post-closing integration. So it is a full part of the transaction that will have implications at every single step, but you are in good hands here at Dean Street Law. If you decide to work with us, you can of course apply through the link in our show notes. I hope this has been a positive and helpful episode, and I look forward to seeing you in the next episode of Deal Making with Laura DiFrancesco. See you there. Thank you so much for joining us on this episode of the Deal Making with Laura DiFrancesco podcast. I hope you found today's discussion insightful and that it brought you one step closer to mastering the art of mergers and acquisitions. If you enjoyed this episode, please be sure to follow and subscribe to Deal Making with Laura DiFrancesco on your favorite podcast platform so you never miss an episode. And if you found value in our discussion, please leave a 5-star review. It would mean the world to us, and share this podcast with your network, friends, and colleagues. For more in-depth resources, be sure to visit our website, deanstreetlaw.com, where you can find articles, guides, and more information on our services. Don't forget to follow us on social media for the latest episodes, updates, tips, and exclusive content. You can find us on LinkedIn, Search Funder, at LMDFrancesco on X, and at Dean Street Law on Instagram. Join us on our next episode where we'll explore more deal-making insights, Cheers and happy deal making.